Okay, next case on the docket is DeSanto Byrd versus Byrd. Mr. Jones, would you like to attempt to save some time for rebuttal?
Yes, Your Honor, if I could reserve 5 minutes, please.
So what's going to happen, you're sort of responsible for your time. You get 20 minutes. The light on the podium will turn yellow when you're into your rebuttal time, and you can take a break then and sit down and reserve the rest of your time or continue to use it as you see fit.
That would be fine. Thank you for the instruction, sir.
Go ahead.
May it please the Court, I'm Michael Jones. I have the honor of representing the appellant here today.
You could speak up just a little bit.
I'm Michael Jones. I have the honor of representing the appellant here today. This is a case in which we indicate that the trial court erred in granting a bifurcation of a dissolution of marriage action by granting the dissolution of marriage itself while still leaving all issues to be resolved. The law in this case is, I think, very, very clear. While generally in civil cases a bifurcation is well within the discretion of a trial judge, and it is within the discretion of a trial judge in a dissolution of marriage action, the discretion of the trial judge is much more constrained and much more limited. He or she can only grant a bifurcation and grant the final judgment of dissolution of marriage in the event and in the occasion of finding what the case.
Are you also arguing that the trial court erred, even if we say that it was it was not an abuse of discretion to grant a bifurcation? Are you also arguing that it was error that the trial court didn't establish some safeguards for the bifurcation?
Your Honor, I think that is what is said in the case law. I think the case law says very strongly.
Are you arguing that?
I have to, I think, Your Honor. If the court were to...
If we were to say that the trial court erred in failing to establish safeguards to protect the assets and protect from dissipation of the assets, you're alleging that Mr. Byrd is essentially, I think in your motion, which is contained in the record, something like close to $1 million. He bought a car, and he did some other things, withdrew $700,000, and if that has already happened, and we send it back and say the trial court erred in failing to establish safeguards, what good are the safeguards going to do now?
Your Honor, we're asking the court to send this case back in order that the dissolution of marriage itself not be granted, the marriage not be dissolved.
Yeah,
Safeguards...
But what if we say that the only error was failing to establish safeguards? And we send it back and say, establish safeguards, but he's already dissipated the marital assets.
Well, there could be other safeguards put in place with regard to other assets, and there can still be, of course, in either scenario, actions for dissipation, for distribution, ultimately, and that sort of thing.
What safeguards were requested by the wife below?
The wife did not request safeguards because the wife requested that the request for bifurcation not be granted and the marriage not be dissolved.
That's what I thought.
Yeah, and the concern I have with the argument that safeguards should have been put in place, as I understand the record, the trial judge deferred the final hearing in order to give the wife time to come in and say these are the safeguards that we want in place, so that he could put those protections in the order, and the wife refused to do that. That's the way it reads.
Your Honor, I might take a little bit different approach to it. I think what happened was the court granted the bifurcation.
Right.
That was sent for rehearing. The court granted a rehearing, not with instructions with regard to safeguards to be imposed, but rather on the whole factual issue of whether, in fact, there should be a bifurcation and the marriage itself be dissolved. The court then had a very lengthy evidentiary hearing. The husband, the appellee, testified at great length as to his religious beliefs, and even if that were accepted as true, that's mere personal convenience. He never established any exceptional circumstance or compelling reason that would grant the bifurcation in and of itself. The error that the trial court made.
Now, you continue to argue that personal convenience alone and the religious...
What about the safeguard
You
issue?
continue to argue that personal convenience alone is not sufficient, but the trial judge was very careful to say, personal convenience is related to the religious convictions, and I find that they exist in this case, but there are other considerations. It's been 2 years, and this thing is dragging out, and went through some other factors. And are you saying that in a case where one side is delaying, and you have those kind of religious convictions and all those factors, that it would be an abuse of discretion to bifurcate if protections were put in place?
You are putting a fact into your hypothetical that I do not believe existed in this
Okay.
case, which is that the party who is opposing the bifurcation was unduly delaying this case. Both parties had complaints or counter complaints. Both parties had the ability to move the case forward.
That was one of the reasons the trial judge gave for bifurcation, was the delay.
But I don't
A
think,
delay.
I don't think it was pointed to the delay of Party X or Party Y. I think it was just, hey, this has been going on for 2 years, let me go ahead and grant this dissolution. And under the facts that were presented, I'm going to answer both. Under the facts that were presented, the fact that it had taken 2 years was not a sufficient exceptional circumstance. And in your scenario,
But what the trial judge said was the combination of things made it.
I understand that. None of them separately, none of them combined together was sufficient to be exceptional circumstances, but the primary reason was this personal convenience and these religious beliefs. And to answer your hypothetical, even with the scenario of finding that Party X that's opposing the bifurcation and the entry of the dissolution actually had delayed, there are sanctions available to the trial court to deal with that type of thing, up into including striking the pleading, setting a hearing, ordering it to meet, imposing attorney's fees. There's all kinds of delay sanctions that were not asked for, not raised, and not brought up in this particular situation.
Getting back to the safeguards, Judge Lawson asked, well, the trial court may have made provision to allow you to come back in and say, these are the safeguards we want, but you didn't do that. And I'm a little bit confused about that now. Tell me what happened. I mean,
My understanding was that the order was entered. There was then a rehearing requested, a very extensive motion with case law of why the court couldn't do it. The court granted a rehearing and then held the evidentiary hearing. I don't believe that it was I don't believe it was reheard, initially set aside, reheard based on, well, we're going to now talk about whatever safeguards are
At the
in.
rehearing, the wife indicated that she was primarily concerned about the assets and dissipation of the assets. But did you ever ask that any safeguards be put in place in the event that the bifurcation was granted or not?
Well, I was not the trial attorney. My law firm was not the attorney in the case.
Speak up just a little bit.
We were not the trial attorney at that time. I was not personally there.
At the hearing, the court says, I've already found that there are exceptional circumstances, and I didn't want to enter an order without giving the wife time to come to an agreement as to safeguards for her. And I thought that's what you've been doing for the last 3 months. And then Mr. Byrd's attorney says, well, that's what we've tried to do. We've attempted to get with them and find out what safeguards we need. Mr. O'Mara, your client's trial counsel, said, well, we're just not going to agree to bifurcation at all. Now, the judge had already ruled, and I'm having a hard time understanding how, given that that's what I'm reading transpired, that the trial judge didn't give your client an opportunity to come up with suggested safeguards, and your client just didn't do it.
But our client...
You said that was inaccurate, an inaccurate...
I didn't say that didn't happen. I said that there was a lengthy hearing and that it was mainly on procedural, on personal preference type of situations.
Well, the trial judge thought he was giving you time to come in and tell him what safeguards need to be in place.
even if the wife did not come in and ask for safeguards in this situation, it was still error to grant the bifurcation and to dissolve the marriage at that point in time. There was no...
Why wouldn't that be a waiver of any argument that, that safeguards should have been in place? And that was trial court error not to put safeguards in place? How can you come up here and say that, you know, the trial judge made this error when the trial judge gave your client a lengthy opportunity and sufficient opportunity, it looks like, to make any kind of suggestion or request?
Yes, Your Honor. The trial court's error, and I will get to that, the trial court's error was in granting the bifurcation. The trial court then...
Okay, so you're basically saying that the safeguard issue is now off the table. I mean, that's not an issue anymore, right?
The real issue in this case,
All right.
the real issue is that it was not granted, but I do want to answer your question. In many scenarios, courts will send parties to mediation, try to work out something. In the case of this case, they could not work out something of safeguards, even though I don't think that really is the particular issue here. When it then comes back to the trial court and the parties cannot reach an agreement on any issue, alimony, who gets the dog, any issue, the trial court makes that decision. So it would be the trial court's error not to impose sanctions. But the real and true error in this case is that the trial court granted a bifurcation without valid reasons to do so, did it on the personal preferences and conveniences of one of the parties. All of the other questions of delay and that sort of thing had other sanctions available to them, other methods available to the trial judge to deal with, or for the other party to deal with.
The harm that your client's claiming, though, as a practical matter, is not that they're no longer husband and wife married. She's claiming because the dissolution was granted early on, husband has now dissipated marital assets. I mean,
That's correct.
That's the claim, correct?
That is what happened, but the legal issue here...
And isn't that what she was worried about would happen? Either they would be dissipated or delayed, all of which could have been dealt with by requesting and having safeguards imposed.
And if the parties couldn't reach an agreement on safeguards, if Party A had asked for safeguard
But if that's the case, then you should have said, Judge, we need this safeguard, this safeguard, this safeguard. It would have prevented him from withdrawing all that money and spending $100,000 on a wedding and buying an expensive car and all this other stuff that you're complaining about now. Don't you think?
Well, of course, when you phrase it that way, that makes logical sense. But the problem and the error came about by...
I understand your argument is the primary reason that the trial judge granted the bifurcation was because of his religious concerns.
That's correct.
Right.
And that any other thing that he mentioned, such as it's taken 2 years, or I wish it had been faster, or any other thing, again, is not sufficient to reach the exceptional circumstances from the Clawton case and the prodigy that come from that series of cases. This is a situation in which we would respectfully request that the court reverse the trial court's decision in this case and remand with instructions to set aside the order dissolving the dissolution of marriage. Whatever time I have left, I will reserve. Thank you. Good morning. As you know, I'm Attorney Jeff Byrd, but in this
Mr. Byrd,
capacity...
I have some difficulty with granting a bifurcation based on someone's religious beliefs. I mean, your wife testified that really you did not hold those religious practices firmly, but that's an aside. My concern is that if we were to render an opinion that basically says that religious beliefs constitute proper grounds for bifurcation, you're going to have every Catholic, you're going to have every Mormon, you're going to have everybody that's got a religious faith or belief against divorce and dissolution coming in and saying, I have to have this bifurcation. That doesn't make any sense to me.
That was an argument that was advanced at the hearing, and the judge specifically addressed that and said, I am not saying that in all religious cases
That's why he said that based on these particular, but when
is
I read
correct.
the order, it seems to me like the primary factor that the trial court was concerned about was your religious faith, and that what you hammered away at, and you constantly made that a theme of your brief as well.
Actually, there were 3 components to the court's order, and I'm looking at page 56 of the record, paragraph 16 of his order. He specifically, even says specifically, as it applies to this case, under the circumstances of the protracted and delayed litigation of this matter, so that's number 1, the history of the husband
Well,
acting...
he said I think the delay had to do with the stress and strain of the continued state of your marriage to your wife, given your religious beliefs. But I understand that the religious aspect, your religious belief aspect of this was not the only reason the trial court granted the bifurcation.
That's correct, there were 3.
So,
Okay.
I'm sorry, go ahead.
No, I was trying to answer your question. There were actually 3 things that were specifically enumerated by the court as it relates specifically to this case. So your concern won't this cause a broad brush, all religious cases, other people's faith, blah, blah, blah. And I understand the concern, and the judge was specifically at the hearing asked that question, and he addressed it.
If we take out your religious faith issue, that would leave that it was a 2-year marriage and that it was going on a little bit too long. And if that's the case, then you write an opinion that says, well, that's a proper basis for bifurcation. You're going to have everybody that's got a 1.5 or 2-year prolonged dissolution proceeding coming in, so we need it bifurcated now, right?
Respectfully, Judge, you're taking out an important piece of evidence. It's like saying,
I'm saying, if I think that the religious faith issue or aspect of this was not a proper consideration for the trial judge to base his decision on, we take that out and we're left with the 2-year marriage, or the 2-year dissolution proceeding. And what else?
May I respond?
Sure, go ahead.
First off, you're taking out the most important piece of evidence. It's like saying in a conviction where you have
That's
DNA. I'm trying to finish.
It really is the most important aspect of this.
I'm trying to use an analogy. It's like saying in a criminal conviction where you have DNA evidence that clearly convicts somebody. If you take that out, what do you have left? So understand that
You don't have much left here, do you?
No, I do have, I do. That's why I didn't even finish. There were 3 things, Your Honor, 3. And I realize you're focusing on 1, and I realize how that could affect cases if somebody's Catholic or Baptist.
But I think you basically argue you're taking out the most important aspect. And it seems to me like that's the most important aspect.
Well, what you're taking out...
Based on your religious beliefs.
Sir, what you're taking out is the facts, the evidence. That's what all judges have to base...
I just wanted to know, if we took that out, what else did we have left to base a decision for bifurcation on? I'm not, I haven't firmly made up my mind about that yet.
I understand.
But
Judge, I haven't even finished answering even that...
We ask that question all the time, okay? If you exclude this piece of evidence and we consider the case based on just what's left, what have we got?
And I haven't even finished answering even that first question for Your Honor.
Go ahead.
He enumerated 3 things. We've discussed this faith over and over. But number 1, he said the protracted and delayed litigation of this matter. And it doesn't matter who's at fault for that. But he enumerated...
Does the record reflect how this relates to the normal time for dissolution cases in any way? I mean, it seems like a long time to me,
Well, I can tell you we're still 4 years later and it's still unresolved.
But I mean, the trial judge seemed to react as if 2 years was a long time. Is it?
On the contrary, it wasn't that 2 years was a long time. It was this case had been dormant for 2 years. I think everybody knows why, because Mr. Romero was involved in another famous case with the Zimmerman case that concluded in July, and then finally our hearing was set in August, for which you have no transcript record of, and then it had to be reheard, for which we now have a transcript in December. So I cited an interesting Supreme Court case from West Virginia that talks about somebody being held in bondage by protracted litigation. It doesn't matter who's at fault. It doesn't matter if it's the opposing party, the mere fact of the protracted litigation, and I realize it's not Florida Supreme Court law, but West Virginia Supreme Court said that that is a factor that could be utilized to
Right, and
grant
my question was
bifurcation.
more toward how protracted is this compared to other Ninth Circuit dissolution cases?
That's a question that I think that the trial judge gets to decide in his discretion. And the record shows that he said, since coming to the Family Law Division, I have denied all other motions for bifurcation and only granted this one. And he emphasized that he understood the extraordinary circumstances and the caution with which trial judges were to rule on the issue. So I can't answer that question because I've never been a family law judge, but that judge
It
did.
seems to me that a two-year dissolution is really, to me, is not an extraordinary circumstance. I mean, that's just not, it seems to me the extraordinary circumstances may be that combined with the fact that your religious beliefs have prevented you from socializing with, other women and having a normal life and that sort of thing, basically.
And then the third factor.
Yeah, get to that.
The third factor that the court enumerated was the history of the husband, now talking about myself, acting in good faith and protecting the assets and providing for the needs of his children and her needs. So he enumerated three things: the delayed litigation, the history of good faith, and then the third factor was the conflicts created by faith. And it's not just my faith as it relates to women, as you implied, but it's my faith as it relates to all of my family. It's my faith as it relates to my co-workers who are all of the same faith, including our bishop. Not only my bishop, but her bishop was an attorney in my office. And you could say, well, then just get rid of him, and then you don't have that internal conflict. But that's not fair to him as a lawyer.
That's absurd to say something like that.
No,
And it has, when you bring religious connotations into a case, and you have to say, okay, well, if this is fair for a person of the Mormon faith, it's fair for a person of the Catholic faith, it's fair for a person of all religious.
And I agree with that.
Have to do, so that goes back to my point, that that's the case. Then, we're opening up a really broad door to let everybody come in and say, well, I've got this religious belief, and therefore I'm entitled to bifurcation.
Well, respectfully, if there's a PCA decision, then there's no opinion that people will utilize or cling on to, but...
That never would have occurred to us, I don't...
But...
Let me ask you a few questions about this motion for...
If I may just respond to that one thing. I do think, though, that's where the court should look at the law that talks about the deference given to trial judges. And while I acknowledge your question, that you're saying it would open the door, isn't that why we have trial judges to review and evaluate that evidence as it relates to those particular people and their reasons why, which is exactly what this trial judge did. By the way, this wasn't a brief hearing. You can see from the transcript, this was very thorough, lengthy, and it was now the third hearing on this very topic. The first two you don't have record of because the appellant hasn't supplied that record, but this is now the third time the judge is having to address and readdress the same topic.
Yeah, this gets to the good faith issue. They filed a motion, I think, for sanctions, alleging, and it's in the record, I mean, they supplemented it in the record, that you withdrew $700,000 from a joint account, that you spent $200-some thousand on an expensive car, and that you withdrew money to pay for an expensive wedding, and so something like $1 million that they're saying that you withdrew, and that creates a grave concern to them about your dissipation of your alleged dissipation of the marital assets. You want to address that?
Yes, sir. May I direct you to page 192 of the record, which is page 66 of the hearing transcript. And I do say with respect, knowing that I'm in an awkward position since I'm also the party, that the motion that was filed is blatantly false. In the year since it has been filed, it has never been called up for hearing. But if you look at the record, you will see even in the record it is inconsistent with that motion. At page 66 of the hearing, there was a conversation with the court in which my former wife testified that we sold a house, a separate house, from which there were $158,000 per person. per person. At the hearing, at page...
That'd be where the money came from the car, is that right?
Yes, sir.
All right.
And, but yet, you have a motion that the court's now asking me about that says, I bought a car with marital assets. Yet the very record shows that that is not an accurate
What about the
representation.
$700,000?
Okay, what they have conveniently omitted, and if this was a court of evidence, you're asking me, so I'll explain, but
I mean, it's in the, I mean, we've got these allegations in the record, and we've got your argument in the trial court's finding that there was this good faith,
Right.
action on your part.
So that motion was filed about a year after the bifurcation, number one. Number two, I can only tell you it's inaccurate, but since this is not a court of evidence, I can't explain to you why. Number three, I can tell you that while that is an argument and a motion, it has never been called up for a hearing. You have no record of any disposition of it, and I
Let me
can...
ask you this, aren't there tools available to a trial court to deal with dissipation of assets, separate and apart from whether there's a bifurcation?
Sure. A hearing on a motion for sanctions could have been held. All I will tell you, since I can't argue evidence in this forum, is that those are arguments and allegations for which you have been presented no record evidence to support them. I disagree with the allegation.
Let me get back to the
Yes, sir.
safeguards issue. Because I was concerned that the trial court didn't put any safeguards on there, but it's also pretty apparent that based on I think it was the second hearing, the motion for hearing, that the trial judge anticipated that would happen based on agreement of the parties coming up with an agreement for safeguards. Apparently that never took place, and I don't think there's anything in the record. I think he's conceded that they never came back and asked for safeguards. I just want to make sure that if you want to address that and if that's accurate.
It is accurate, except that this was now the third hearing. There was a hearing...
Okay, I didn't remember it was the second or the third, but one of
Yes,
the
sir.
hearings, the trial court anticipated that y'all were going to get together and come up with an agreement for safeguards, but that never occurred. Is that right?
Correct. The hearing of August 23rd, the court received evidence and made a ruling. Then there was a hearing on September 16th to have the order entered. You have no transcript of either of these hearings. And then the third hearing was December 6th, and the court is saying basically to the appellant, what have you all been doing the last 3 months? I've already made a ruling. I've made a finding of fact. He gave them an opportunity to re-receive all of the evidence all over again because now there's a court reporter. But what safeguards do you want? And Mr. O'Mara's response was, well, we just don't agree that you can even grant the bifurcation. So there were no safeguards.
Regardless of how we rule?
Yes, sir.
Is there anything preventing the wife from going back to the trial court and saying, we need these safeguards imposed at this point in time, and the motion that hasn't been called up can be part of that discussion or hearing?
As an advocate, I would say I don't know of any reason that they can't file that motion, but that's up to them. Having said that, they filed a motion for sanctions. Now, let me make sure that the record is clear. That motion is in response, by the way, to a motion for sanctions that I had filed, or my attorney had filed, concerning her withdrawing funds. So you don't have that motion as part of this record, but if you read what she had filed, that is in response to that motion. So I don't think that this is the proper forum.
The motion for sanctions has never been heard, so we just have the motion for sanctions in the record,
Correct.
and that's it.
And that's it.
All right, okay.
And honestly, that's why the trial judge, if it's ever set for hearing, called up for hearing, the trial judge can receive evidence and dispose of it. The real issue here is whether, I heard counsel say that the court committed error, there was error. That is not the standard of review. It is abuse of discretion. So the question is whether the court abused.
According to the case law, it's a narrower discretion than you would normally have.
I have not found that in any case.
You haven't seen that in the case?
No, I actually looked because they said that there was this new standard of a higher scrutiny of abuse of discretion. There's only about 4 cases that address this issue, one of which is a Florida Supreme Court case.
That this should not be granted unless absolutely necessary.
Must be
Forget the name of the case.
an exceptional case.
Exceptional cases.
Well, that is true. That is true.
That's not the same language you usually hear in the plain old abuse of discretion standard. It's,
Well, okay. I agree that it has to be an exceptional case, but still, the determination is whether the court abuses discretion, not a higher scrutiny abuse of discretion. But since you brought up the Supreme Court case,
Discretion in determining that this is an exceptional case, I guess is the question.
it's like saying, I object, no, I strenuously object. It's the same thing. Abuse of discretion is an abuse. I do want to talk about that Supreme Court case just briefly, if I might. I know what you're referring to. That is dicta. They actually approved the bifurcation in that case.
parties agreed to the bifurcation in that case.
Well, they approved of the procedure. It says right here, we approve of the granting of
Well,
this.
I think it's clear, though, that the Supreme Court was saying that you just don't grant bifurcations as a matter of procedure. Of course, you have to be very careful. You don't do it in all cases, and that's
Correct.
exceptional, and there has to be some very good reasons for that.
Yes, and that is exactly
And
what
that's
the,
not your typical abuse of discretion standard of review.
it is still abuse of discretion. No matter how you split the apple, it's the same way. But in any event, that case, I want to get back to Supreme Court case, said the convenience of one of the parties for an early remarriage does not justify its use. You have in the record the fact that I have now remarried. I represented at the hearing that I hadn't even had a relationship, okay? So you can take me at my word or not, but coincidentally, not because of this motion, but the byproduct of the court's ruling did allow me to do the very thing I wanted so badly, which was to move forward with my life, finally meet somebody, and instead of living with them or whatever under my faith, you marry somebody before you undertake that. So you have in the record the fact that I did remarry. Now, the Supreme Court said you should not grant it. I want to make sure I'm accurate in quoting the Supreme Court. It says the convenience for an early remarriage does not justify its use. I ended up being remarried 3 years after the dissolution, so I don't think that that meets the definition of an early remarriage. But I am telling you, based upon the record, believe me or not.
Well, I mean, I understand the serious consequences of entering an opinion that says that the trial court erred in granting the bifurcation and that order is reversed. We understand the serious consequences to you of that. And we don't take that lightly, but then again, I mean, that should not be a basis for an opinion to say, okay, well, simply because the litigant went out and remarried, that necessarily, puts a pall of that we approve the bifurcation based on that reason alone.
I agree.
Ridiculous.
I'm not seeking to establish some new legal precedent. I guess, since I only have a minute left.
I don't even know if that's a consideration we should look at when we determine whether the trial court made the right decision on this particular
I
case.
think
What
it
you
should.
did afterwards.
I think it should be consideration if the goal of our judicial system is to ensure that justice is done. And justice isn't defined by...
Serious consequences of...
Exactly. And so the question is whether that's a just or unjust result. Since I only have 1 minute, if I may conclude. We hear in the law terms like detrimental reliance. So on this topic, I would like to coin a phrase, as silly as it may seem, called beneficial reliance. That when the court rules and you have a finality, you should be permitted to move forward. And it is happenstance that I did meet somebody afterwards, went on a first date afterwards, and then developed a relationship that has led to remarriage for me. That is the best thing a trial judge could ever do for any litigant in a case, to allow them to move forward with their life.
Was this case ordered by this court to mediation?
Good question. It was never even asked for. So we talk about safeguards. They didn't even ask for a mediation. But to answer you afterwards, it has been mediated. Yes, sir.
Okay, so when this appeal was filed, we ordered the case of mediation. Obviously, that was unsuccessful because you're standing here today arguing the case.
I don't know if it was mediated because of your order or if it was mediated because the parties agreed to a mediation. In fact, I actually do know the answer. We mediated the case, and then when it was unsuccessful, they filed their notice of appeal the next day. That is actually my recollection of the timing.
I don't think our mediation rule applies to...
Apply to this?
Right. I don't-
Probably should be.
I think I've used up all my time,
Okay.
so thank you.
point was cleared up.
Let me
but
ask you about...
This was not appellate mediated.
Okay. Let me ask you about the abuse of discretion standard and how you see this, or how you think this ought to be decided. Are you suggesting, and it seems like you are, that we should write an opinion saying that it's an abuse of discretion under circumstances of delay for a trial judge to consider, as part of exceptional circumstances, religious faith and beliefs of litigants?
I am. We have always raised this in our brief as being an abuse of
I guess
discretion
it's
case.
not really a First Amendment issue, but don't you think that that's sort of inconsistent with our country's founding documents, Bill of Rights, First Amendment, that we're supposed to not establish religion, but we're supposed to accommodate it as well? I mean, how can you have a ruling that you can't even put on testimony about how your religious convictions and belief affect you in a circumstance like this? I mean, that seems just as problematic as what Judge Sawai is concerned about legitimately, which is the opposite, which is saying that religion can't, once you say that it can be a factor, then, probably will always be a factor, but isn't it a problem to say that you can't even testify to how that affects your actions? And
I don't think there was any prohibition against the testimony. My position is that it's not,
but I mean,
it's not
if we say it's an abuse
sufficient.
of discretion to even consider it from now on, I mean, there'd be no relevance in that, in any hearing related to bifurcation.
I believe that it is not an infringement upon the exercise of religious practices. There's no religious practice that's being prohibited. The litigant is free to go to whatever place of worship, do whatever he wants to do. The requirement of requiring that the dissolution of marriage be completed would apply equally to all religions and to no religion. It's not an infringement or impingement in any way on religious practices or beliefs. He's not being asked, no litigant's being asked to renounce whether you can date, remarry, engage in X activity or Y activity.
So is it an abuse of discretion to consider the length of the litigation?
I believe that it is also an abuse of discretion. If the reason is stated that it was dormant for 2 years because an attorney was involved in a high-profile case, that to me would be the time the litigant would be pressing and moving and taking advantage of the situation.
Some examples of if a trial judge can't consider a lengthy delay, can't consider a person's individual circumstances based on the consequences of their religious beliefs, how narrow is this discretion when determining exceptional? Is it like only if somebody's about to die? Is that the only case when it can happen? Or?
No, the case law has established, but I would agree with you. It is a very limited circumstance that it can be done. The case law, I think, talks about to die as one of them. A situation in which there was a property that had to be conveyed in a certain title. That's a situation that can do it. The situation that happens when we might have jurisdiction for 6 months over the marriage because the petitioner in the dissolution is a resident of the state of Florida, but not jurisdiction over children.
By assigning this issue an abuse of discretion standard of review, didn't the Supreme Court necessarily give trial judges a lot of latitude to consider a lot of issues? I mean, it seems like you're arguing that maybe this shouldn't be an abuse of discretion standard.
Well, I have to deal with what the case law says. The case law says it's an abuse of discretion, but they have made what I believe Judge Edwards indicated, perhaps a higher level of abuse of discretion. They haven't come out and said that, but they have given a definition of a very limited and narrow circumstance in which there is that discretion. And when that...
One of the primary reasons that the trial courts say that bifurcation should be the exception rather than the rule is not only piecemeal litigation to prevent that, but primarily to prevent one party from kind of dragging their feet and dissipating the marital assets and never coming to a final resolution of the case. And it seems to me that the primary concern is is to prevent bifurcation, to allow the other party to then proceed as they are divorced, and then take care of the assets later, and allowing one party the opportunity at least to either drag their feet and never get the case settled, or to dissipate the assets. Isn't that basically the primary concern about bifurcation? And if that is a primary concern, then you really didn't take the necessary steps, or the trial lawyer that tried the case really didn't take the necessary steps to put the safeguards in place that would have prevented that.
I don't think that's the primary concern. The primary concern is to avoid piecemeal litigation, get it all resolved at once. When people get divorced, their status changes.
You would concede, though, that a primary consideration is instances where bifurcation is granted, the divorce is complete, the people are free, but the assets are still out there, and one party may control the assets more than the other and give that party the upper hand in controlling the course of the litigation thereafter, and having the opportunity to dissipate the assets. That's a primary consideration too, isn't it?
That's one of the considerations. The relationship of the parties to their property changes. They change from being marital by the entireties to by the tenants.
That seems to be your client's primary concern, because he talked a lot about dissipation of assets, that he withdrew $700,000. He bought a car. He did all these other things, but then your client never took the steps that she could have taken and can take after you leave this courthouse, to prevent him from doing that in the future, if that's indeed what he has done.
If I may make 2 points with regard to that, Your Honor. First of all, the burden is put by the Weasel case, is put on the trial court with specific things that are listed, not a comprehensive list, but specific things that the trial court should consider putting in. The fact that the party, from a litigation point of view, decided, we don't want this, so we're not going to go to a fallback position, and we didn't go to a fallback position in our brief either. There's two sentences, respectfully, Your Honor, in which we set out for pages of why it's illegal, why it is a abuse of discretion, which is an error at that point. Did not say it was an error of law, have never said it was an error of law, and then made in 2 sentences, hey, it may have happened in this case as well. This is not a separate point on appeal. This is not a separate request for this court to send this case back for a remand to impose what Weasel said that the court should have done.
It seems to me the primary theme of your argument in this case is that he's done all these things to dissipate the assets, and now she's in dire straits, and that we need to have this sent back and have the bifurcation order reversed. You would concede you can go out of here today and then go have that motion for sanctions heard, set for hearing. You can file other motions, and you can still today file motions for safeguards to prevent Mr. Byrd from dissipating any other assets that may be remaining, or to have him put back perhaps the assets that you can prove that he did dissipate. You can do that today, can't you?
Absolutely, Your Honor. All of the trial court remedies are still available, but that's not the point here. The point is that the court abused it. We understand your point very clearly, that you say the trial court erroneously considered the evidence of his religious faith and the length of the proceedings and that sort of thing, and the bifurcation was erroneous to begin with. And I think Appellate conceded that the most important part of the order was his religious beliefs, and I don't...
If there are any more questions, you've exhausted your time. Any questions?
One more. If we quash the order, that doesn't get your client her property back that she thinks she's owed, does it?
No, it doesn't, but it restores her to the status of owning property by the entireties, which is a different legal standard than tenants in common.
Okay. Thank you very much for your argument.
Thank you.
Court's in recess.
Thank you. We'll argue on both sides.